to introduce Justice Charlie Wells, who many of you know is a graduate of UF and of the law school at UF, the Levin College of Law, and who was the Chief Justice of the Florida Supreme Court in 2000 during Bush versus Gore. He practiced law in Orlando, went to the court, and is practicing law again in Orlando. And we're hoping we can convince him that he needs to come move to Gainesville, because we'd like to have him here. But until then, I ask you to enjoy his talk, and we'll have time for questions and answers.
How's that? Okay, well, let me get a hold of this other piece of electronic equipment. I'm glad to be here. I know many of you, and in fact, I've seen Cecil Edge out there. I hadn't seen Cecil, as I said, since 1906. And I'm glad to see that Cecil's still moving, I'll tell you that. But it's very good to be here and take a short trip down memory lane back to the year 2000, because I'm going to go through the story of what happened in the case of Bush versus Gore as I saw it from inside the monastery called the Florida Supreme Court, and give you some idea. The story really is about the transfer of power of the top position in this country. But it's also a story about the Supreme Courts. And I know that just the mention of Supreme Courts is enough to put many people to sleep. And it's, in fact, reminds me of the story that one of my former colleagues, Harry Anstead, often told, and that was about the little boy who went with his father to see the U.S. Supreme Court in action, and they came out in their penguin outfits and sat up there on the bench, and all of a sudden there was a fly that was swarming around the nose of one of the justices, and he went, and the little boy said to his dad, "Look, Dad, one of them's alive." And I know that's the feeling, but as this election of Bush v. Gore occurred on November the 7th of 2000, I know all of you don't remember it like I do. I got up, and we had a house in Tallahassee, not far from downtown where the court is, and Linda and I had each gone. I was headed to the court because we had an oral argument down at the Florida Supreme Court that morning, and so I stopped by the voting booth on the way down to the Florida Supreme Court, and there wasn't that big a line at the voting area where we were, so I just cast my vote and got back in my car, headed on down to the court. By golly, my duty of electing the president in the year 2000 is over, and we would just get on down there. So we went on down, and there wasn't really much chatter as we went into oral argument. We have oral argument at the court 1 week a month, and meaning that we would hear 4 cases in the morning of each day, generally happened the first week of the month. This was particularly, we were having it that had begun on Monday, November the 6th. Then went through the oral argument and went home. And Linda and I had always, Linda's father had been very active in politics. They, as I often said, Linda's dad and her mother brought the Republican menace to Florida, because they were Republican when it wasn't cool to be Republican in Florida. And he would have been for 8 years was the chair of the county commission down in Pinellas County. And so Linda had been, and I had always been very interested in politics. So we settled in and started watching the election returns that night. And and you remember that about 7:30, the networks projected that Florida was going to go for GORE. And I thought to myself, that's kind of strange, because I knew something that I think most observers in Florida knew, that the Panhandle, which was all of the counties west of the Chattahoochee River, their polling booths didn't close until 8 o'clock, and that was probably going to be a large vote there, all the way over to Pensacola, for Governor Bush. And so, but at any rate, they called it for GORE, and then you remember they withdrew that call about 30 minutes later, and then they didn't call it again, and for a while, and it got past my bedtime about 9:30, and I went on up, and Linda and I went on up to bed. And we have this habit of each one of us has a small Walkman portable radio. And so had those radios in our ears. We went to bed, and they were having the election returns. I finally went on off to sleep about 11 o'clock, and by that, it was at that time too close to call. And then I woke up about 2 o'clock, and I got up to do my 2 o'clock business, and Linda said, "They've now called it for Bush." And I said, "How many votes separate?" And Linda said, "Less than 2,000. And I thought to myself, like the astronauts on Apollo 13, Houston, we got a problem here, because that's too close, because I knew there had been about 8 million votes cast. And I also knew that the absent, I didn't really know for certain, but I assumed that the absentee vote was not in that, but that it was going to be very close, and that they were already projecting that this was going to be all across the country, that Florida was going to, in fact, make the difference. And then as this thing began to dawn, that was the headline in the paper as we began today on November the 8th. That was the headline in the Tampa Tribune, that it was in fact too close to call. And by the time I got down to the court, we were, as members of the court, we gathered behind where you have oral argument there at the Florida Supreme Court, and there was slight chatter about it, but we really hadn't gotten the sense yet that this was all going to become a substantial controversy, but it had the potential. Even as we gathered at 9 o'clock on the morning of November the 8th. We went ahead and had oral argument, and I got back up to my office, and which is on the second floor in the front of the Supreme Court building. And by that time, I got word through the clerk of the court that there was controversies arising because of something that happened in Palm Beach County called the butterfly ballot. Now, the butterfly ballot had fluttered to the top here all of a sudden. And so that was the first wind that there was going to be a problem. And what that had to do with was the form of the ballot. So I immediately took a look at the statutes to see if there was a statute that had to do with the form of the ballot, and I found out there really wasn't anything that would prohibit the supervisor of elections in any individual county from designing the ballot. And so in Palm Beach County, the supervisor of election had designed a ballot in which they had presidential candidates on each side and a place where you punched your card in the middle. And that gave rise to a lot of confusion, and people who were saying that they intended to vote for Vice President Gore had in fact voted for Pat Buchanan. And that was definitely the reverse of what they intended. I was very certain of that. But that was the reports that were already arriving with us. Then on that Thursday, we were greeted by newspapers that they had done a machine recount, which Florida required by statute when there was an election this close, that they had to go through and do machine recounts. Now, one of the things you got to understand, the Hallmans has a piece of memorabilia that is an actual voting booth. Where are Joyce and Bob? There they are, right over there, and they had procured one of the actual voting booths from down at Fort Lauderdale. And what you'll see in that voting booth, if you'll take a look at it after in a little while, and you'll see that it has what was the major offender and caused the major problems in this election, and that is a punch card ballot. And we were just by that Thursday beginning to get wind of the fact that there was a real problem with the casting of these ballots, because there were a lot of concerns that were being raised down in the South Florida counties, the most populous counties in Florida. And so now by this time it's Thursday, and I had heard that these punch card ballots, with this vote being so close, that there was a lot of contention that there should be a recount manually of these ballots. But there was the Bush people did not agree that there was a right to manually count the ballots. And so the controversies were beginning to form, and with each passing hour in Gainesville, in Tallahassee, the word was reaching us that we were going to, in fact, be in the middle of a lot of litigation. And so I did it was homecoming weekend down here in Gainesville. And so, like a good gator, I came on down here. And as Linda and I were driving down here, we were listening on the radio, and there was a lot of discussions that Friday about the fact that all of this controversy was now bubbling up. And I heard on the radio that Bush had filed suit. But he had filed suit in the federal court in Miami. And I thought, yes, that's the answer. Get it over there in the federal court. it was assigned to Don Middlebrooks, and Don was a good friend of mine. I'd known him since he began to practice law. He started practicing with a firm in Orlando, and then I knew him better when he was Reuben Askew's legal counsel. And I knew he was a decent sort of fella, and that he was the type of guy that might keep this from me, which I would have been very pleased about. And so they went into the United States District Court down in Miami on that Friday afternoon. But in Gainesville on November the 12th, before I get to the statutes, Linda and I were staying over at the Residence Inn, and when you turn on the television and they had pictures of Volusia County. And what the supervisor of elections in Volusia County had made the decision to do was to manually recount these punch card ballots. Now, the problem that you had with these punch card ballots, it became very evident, was that, and you'll see it when you look over here, is that there's a place where you punch the card. But if you didn't punch the card all the way through, then there would be what would be called a chad. And that became part of our language, the chad, which I doubt that many of us, and I certainly hadn't ever heard of a chad. But it became so popular, CNN started talking about having a TV program called Chewing the Chad. And the problem was that if the ballot wasn't punched all the way through, then you put it in a machine and it wouldn't count it. And so that became a problem of undervotes, in that there would be votes on a ballot for all of other offices, but the presidential election wouldn't be picked up. And so by the time they were trying to discern from the ballots in Volusia County on that Saturday whether, and they had a whole bunch of people sitting around a table with all of their ballots, and they were examining them, and they were trying to figure out who a person intended to vote for by looking at the ballot if it had not been picked up on the machine. And so when I got back to Tallahassee, there had also been information in the press about the fact that there were some time limits that were involved in whether there could be when these ballots and the certification of who won in a county had to be done. So I got back to Tallahassee on that Sunday and went down to the court, pulled the statutes, and what I found was very disturbing, to tell the truth. And that was that there was a statute, 102.111, which says that if the county returns are not received by the Department of State in Tallahassee by 5 p.m. on the 7th day following election, all missing counties shall be ignored. Shall be ignored. But right below that, in 102.112, was a section which said returns must be filed by 5 p.m. on the 7th day following the first primary general election. If the returns are not received by the department, such returns may be ignored. Now, believe me, there were lawyers all over America that were salivating at the fact that we had a conflict that just was unresolvable when you read the statutes, because as you've certainly know. The word shall is a word of command, whereas the word may is a word that has within it the exercise of discretion. And we were working on a very short time frame, because by this time it was already 5 days following the election, and that both statutes provided that those ballots had to be completed within 7 days. Now, there was also another provision that was of concern, and that was that there could be a protest filed. But the problem with 102.166 was that it meant that any candidate could file a protest and request from the county supervisor that there be a manual count of the votes, of the ballots, up until the 7th day. And the statutes didn't leave any time to do the recount. And so we were we were in the soup there with these statutes. And so that was one of the major problems that was seen right at the beginning of as this began to develop. Now, things were not exactly calm out in the provinces here. And as you remember, people were beginning to get on edge, and this was on the 13th of November. And so we also began to collect a lot of media out in front of the Florida Supreme Court. And in fact, by that Tuesday, which now we were 7 days after the election, we had 3 blocks of video trucks across from the court. Well, by that Sunday afternoon when I went down to the court to review the statutes, there was already a media team that had set up a tent on the lawn of the Supreme Court. And we had to get that moved, and in fact, by the 15th, there was an entire tent city across from the Florida Supreme Court on the steps of the Capitol that had been set up by media around the world. Now, what happened on the 14th was that there began to be a lot of rumors that there was litigation filed, reports of litigation. Well, more than rumors, that we'd gotten information from down in Palm Beach and Broward and Dade counties that there were suits being filed, and that there were going to be a suit brought by Palm Beach County Canvassing Board directly in our court. Now, one of the problems that you have in a situation like this is that there are a number of rules that courts have to follow. I mean, courts are not commissions. You don't go out and reach and grab a controversy and bring it to you. We had to wait for matters to come to Tallahassee. And one of the things that had to occur was that it was under the proper procedure. They had to be filed in a circuit court, in a trial court, so that we could get a trial court ruling. Fortunately, Volusia County had filed a suit when it was running out of time to complete its ballots, and they had properly filed a suit in the circuit court in Tallahassee. And that was assigned to Judge Terry Lewis, who by the 15th was hearing that case and making a determination as to whether or not there could be an extension of time for the manual counting of the votes. And there had been, by the 15th, a lot of confusion that had developed because the Catherine Harris, who was, as you recall, the Secretary of State, had said that it was in her legal, the legal people in her office had issued an opinion saying that under the statute, it was mandatory that these votes had to be in Tallahassee by the end of the 7th day. And so 14th, time had run, she couldn't take any more ballots, and that was what she wasn't going to take anymore. The Attorney General had a contrary opinion, and he had said that there could be a recount and that the manual counting should continue. The problem was that normally the court is going to give deference in election matters to the legal opinion of the Secretary of State's office, the Division of Elections, or there's also the court is going to give deference to an opinion of the Attorney General. But we knew that Bob Butterworth, the Attorney General, had been active in Gore's campaign, and Catherine Harris had been active in Bush's campaign. And so that really, I think one of the lessons that came out of this whole fracas was the fact that it would be really a better thing if the administrators of the election were not identified with one candidate or the other, because when things break apart, then you're really in need of those administrators having some objectivity that the public believes they have objectivity. And in the circumstances here, but at any rate, Secretary Harris had made the decision that she wouldn't extend the time. Judge Lewis, who was the trial judge in Tallahassee, he made the decision that what happened was the Volusia County had filed a petition asking him to extend the time, and he entered a ruling saying, well, she is right that the 7 days prevails, but she has to act reasonably in taking any amendments, supplements to what is filed by that time, and that she would have to set out reasons why she wouldn't take a report that was votes that were counted after that 7-day period. So that immediately, of course, gave rise to more litigation and to a lot of word that there's the press corps on the steps of the Capitol, and immediately word that there was going to be a case that would be appealed, that Judge Lewis's ruling would be appealed. What happened was Catherine Harris did set out rules, reasons that time could be extended, but they were such things as act of God or a hurricane or things that really were not going on at the time in this whole set of facts that we were dealing with. And so what came then to us was the issue of how soon we were going to get in the case. Now we had another problem was that by this time I'd looked at the federal statutes, and I had seen that under the federal law having to do with election of presidential candidates, most of the decisions has to do with election laws in the states. But the Congress had passed a law which coming out after the 1876 election, in which there had been the Tilden Hayes election, in which there had been almost a tie. And what they had done at that point was say that a state had to make a final decision on any controversies in respect to their electors who would be at the Electoral College 6 days prior to the meeting of the Electoral College. And that if a state met that time period, then the decision within that state as to its electors would be final. So when I had my staff, we pulled down a calendar and we counted up those days, and so it became apparent that we had until December the 12th to get all of this handled. And we'd also come upon another complication, as if you didn't have enough to keep you awake at least until 11 o'clock. And that was that this protest period that we were in now was only half the story. Because after you completed this protest, then either candidate that was dissatisfied could go back and ask a circuit judge to set that decision aside, and you'd bring it back up in what was called a contest. And so that we had to go through the protest phase. We also had to go through the contest phase. And in the interim, we had Thanksgiving. Now, Thanksgiving was the following weekend. From where we are is November the 17th. And so what we decided, we knew the case was going to get to us. It first went to the First District Court of Appeals, but then they didn't want it. They waved it on to us. And so we had it, and first we set a very short oral argument period. Now, by this time, it's Thursday. We set oral argument for Monday. And since I was the chief at the time, it was my responsibility to do the administrative things. We had to figure out how we were going to handle all of the world's press that was there, and we worked out an arrangement with the networks that they would use our feed, and that we regularly televised our oral arguments, and that we would have a pool of reporters so that we could also have members of the public. And we got all of that worked out and set the oral argument for 2 o'clock on that Monday, thinking that it was really necessary for us to get a decision out in this matter before the Thanksgiving recess as to whether this counting could continue or not. Because the longer that we didn't have a decision as to whether it could or couldn't, the more tension was building. And we didn't want to let that go and not have a decision out of our court before Thanksgiving as to whether there could or couldn't be a count. We also made a decision that we needed to keep the status quo. They were in fact in Palm Beach, Broward, and Dade counties, which is where the GORE people were saying that this contest really needed to, whether the recounts needed to go forward, that in those counties there were so many voters and there were so many votes that it just was, practically speaking, very hard to get all of those votes counted. So we entered an order saying, let the count go on until we have an opportunity to hear the case and keep the status quo. And so we entered that order and made it through the weekend as crowds began to grow. Now, there was also another controversy that happened in Tallahassee, because that was the weekend of the Florida State game, which was a real problem because all of these reporters, they had to get out of their hotel rooms. And it was, we just about were going to have a riot there. But as you can see, my office was right behind that upstairs, and I looked out, and they were having a hell of a lot more fun out there than I was inside the building. I looked out there one time. There was a lady that had brought her pet skunk, and she could make that skunk do backward flips. It was, of course, they were there to depict that what was going on was a circus, and I know that was the feeling of many. But these folks, they had everything in perspective. Now, Sandy Dallenbert, who was president of Florida State at the time, invited us all to go to sit in the box, and we normally went. It was a big weekend, but I decided, discretion being what it was, that it would be better not to go and partake of things, the social events. So Linda and I watched it on television, and it turned out it was very fortuitous since Florida State won 30-7, and I was glad not to have endured that. But then we moved on, and that weekend, of course, we spent reading the briefs and working through. That's my colleague Leander Shaw, who was the senior member of our court. That's Barbara Perriente and Major Harding, who were members of the court at the time. And then we had the oral argument. People lined up to come to the oral argument on the 20th. And we had quite a collection of celebrities. Both Bush and Gore had their own Secretary of State there. I think they were well represented. And that's David Boyce, who was making the argument on behalf of the Gore team and who did an excellent job throughout the whole event. The lawyering was exceptional, especially in view of the short string that we had the lawyers on now. And then we issued our ruling on on that Tuesday. Now we spent all day, we did something that was very unusual on that Tuesday, in that we had met immediately after the oral argument on Monday afternoon. But by the end of the argument, about 6 o'clock, we were all very tired, and so the members of the court are only one gathered in the conference room when you're making decisions as to case, and this was a matter that obviously not only urgency, but that it was very tedious to figure out how to resolve these conflicts in these statutes. And so we had adjourned, and we're coming back the next morning to decide the case. And the next day, though, the legislature was convening in organizational session, and I had agreed some time before to swear in the new Speaker of the House and the new members of the House. And Major Harding had agreed to go over and do the same at the Senate. So there were such great crowds between us and the Capitol, as a matter of fact, and we're right across the street, as you saw from the pictures. The Florida Department of Law Enforcement had to drive us over and underneath the building so we could go in and get that done. But so we really didn't get to come back and start working on our opinion until shortly after noon. But then we spent the afternoon and did something that was very unusual for our court, and that was that we made a decision, and in this instance we had a lot of things to work out, because we were all very much of the view that there needed to be an extension of the time for the counting because of all the confusion that had gone on and whether the count could be done or couldn't be done. And so, but we had to figure out a time. If we were going to extend this 7-day period, how long could it be extended? And we had asked the lawyers that in oral argument. In fact, Major Harding had asked the question. They said, "What, are we just supposed to reach up in the air and divine it, the date?" And so we had to take a great bit of time and negotiate among the 7 of us the time that we would extend it to, and to work out the details of the opinion. But in what I said we did was something that was unusual, in that we all 7 sat there all afternoon and wrote the opinion. And then when we had agreed upon various things, we had one of the judicial assistants come down and put it in the computer, and we did get it done by about 6:30 that night. And it was ready to be issued. But back in 2000, we also issued paper opinions, as well as sending things out electronically. And as things go, when we were ready to go and the whole world was waiting on our decision, the copier broke in the clerk's office. And so it was 2 hours before we actually were able to get it worked out and got it put out the door. So we got it out the door, and I went down and got in my car and was going home, and I was tired, and immediately I could tell that what we had decided was not meeting with universal acclaim, especially among the Bush people. They were very upset that we had extended the time, but in my judgment, we had to resolve this conflict in the statutes, and in fairness, we had to extend the time, but we extended it through the following Sunday because we had to take into consideration that it all had to be finished by the 12th of December. And that there was this second phase of this, the contest phase, that had to be gone through. Well, of course, we got a lot of national press, and there's my Halloween picture from 2000. Actually, that picture did run in newspapers around the state, and a friend of mine who lives in Maine, who some of you know, Ted Phelps, he went into a convenience store, he says, to get that newspaper, and he walked up to the counter and said, and the woman who was tending to the store said, "Sir, you know that paper's 2 days old." And he said, "Yeah, well, I'm getting it because that's my friend's picture." And she looked at it, and she looked at him, and she looked at it, and she said, "Boy, does he look pissed." Well, that was not really how it was, but I can certainly understand that type of response from that glare. But that was the way that the newspaper headliners headlined what we had done in our first opinion. Well, Linda and I had gone on down to, she had gone ahead, and then I had figured out that I could go to Miami, where our daughter and her husband were both in medical school at the time, and so I went later, and we got down there, and by the time that I got to Miami, there was already a ruckus in the Dade County Courthouse. And the reason for the ruckus was that the Dade County Canvassing Board had made the decision that afternoon that they could not complete their counting by our new deadline, of Sunday. And so they just said, we're not going to count any more votes. So immediately the GORE people filed another lawsuit and went into the circuit court in Dade County. That went to the District Court of Appeals in Miami. And by that Thursday morning, which was Thanksgiving, we had a reason that the District Court of Appeals had denied help, but had been gracious enough to say we're doing it without prejudice to the Florida Supreme Court being able to give you some help. So that was an invitation to come to us, and by about 9 o'clock that Thanksgiving morning, they in fact filed a petition. And so members of our court were scattered all over the country, but our clerk was able to get a hold of everyone, and we had a telephone conference, which was a very important telephone conference. I was in the bedroom of our daughter on Brickell Key in Miami, and we just had all the briefs and their petitions faxed to us, and we considered those materials, and we issued an order and made the decision that we had already crossed the bridge and that we had ruled that everything had to be completed by Sunday, and that was as far as we could extend the time. And so we denied the petition. And so that's set up, and they were doing actively on television. I remember watching it. I tried to watch football games, but they kept showing the people in Broward County down in Fort Lauderdale, where those ballots were, on the television, holding the ballots up to their forehead and putting them up like this and trying to discern what had happened on these punch card ballots. And so that we, of course, didn't have anything further for our court that time, and we went on, I remember on that Friday, over to Coconut Grove, and Linda and our daughter and her husband and we all went to the movies. I got out of the movie and I had a call on my cell phone, and it was from Greg Waters, who was the public information guy at the court, and he said the United States Supreme Court has taken the case. Well, it had been indicated in the news that the Bush people had filed a petition in the United States Supreme Court to have our decision of November the 21st reviewed. But I was absolutely shocked when I got that word on that Friday afternoon that the United States Supreme Court had decided at that point to take the case. And the reason is because Bush had filed a petition and there had not been a certification one way or the other as to who the winner was, and that was going to be done on Sunday. And if Bush won that certification by the Secretary of State after our extended time, then Bush wasn't going to have had suffered any damage. And so I thought it was very unusual in my experience for the United States Supreme Court to step in and make a decision to take a case prematurely like that, because it would go ahead and resolve itself. And so Linda and I went back to Tallahassee on Sunday after having received that word and watched, like the whole nation did. There was the Catherine Harris appeared with the Florida canvassing board, our election board, on that Sunday evening, and and in fact, Bush was certified by her to be the winner. And so I thought, boy, surely the U.S. Supreme Court, who had set their oral argument for the following Friday, was going to dismiss that case because it was now moot. But Monday came, and then we were walked on through the week, and they didn't. And so, but we went on about our business, and because there were a lot of other things happening at our court still. For one thing, Governor Bush, Jeb Bush, who I think must have concluded we didn't have enough to do, set a couple of executions, and which always means that we at the Florida Supreme Court had to review those cases. We did stay those and moved, but then there was, what was going on was, in this picture, was that we got word that there was some demonstration that was going to come from Florida A&M, and so Reverend Jackson and Congressman Rangel, and we had a really superb person who was a marshal at the court at the time, Wilson Barnes, and he was able to work it out where we never had any incidents at the court. They wanted to have their speeches to begin with. They wanted to have it on the steps of the court, and I didn't think that was going to be a good idea. First of all, we had oral argument going on again, and so they had to have people be able to get in and out of the court. So they moved it over to where to the side of the lawn, and so we went on through that period and didn't have any issues. Now on December the 1st, the U.S. Supreme Court had heard oral argument. People are gathering around our court again, and on what had happened by then was that there had been a contest filed in the circuit court in Tallahassee, and that was assigned to Judge Sandy Saul. So the U.S. Supreme Court was hearing this argument all the week of the 28th and up until that Friday. Judge Sauls had all of the Dade County ballots sent to Tallahassee to his court, which Dade County had not counted. There were about 9,000 ballots. And you may remember seeing on television, it was like watching the O.J. Simpson chase, that Ryder truck coming up I-95, and they had been taken over there. And so Judge Sauls was making a decision as to that, whether those ballots should be counted and whether several other counties had ballots that should be counted. And by December the 5th, which was Monday, he was going to rule, and we also got word that the U.S. Supreme Court was going to rule. And so that was a big day in the life of this dispute, and we got the information. Everybody is waiting to see what is going to happen, and what happened first was that the U.S. Supreme Court did what I thought in football parlance they were going to do. They punted. And that was, they remanded the case to us, and they said, give us more information as to the basis of your ruling, which was really a non-decision at that point by the U.S. Supreme Court. But the Judge Sauls had ruled, and he ruled that he would not count those Dade County ballots, that there had been, it was within the discretion of the election board in Dade County as to whether they were going to be counted or not, and that he ruled totally in favor of Bush. So now GORE files another an appeal from that, which is going to come to us. By now, where are we? We're on December the 6th. And this has to be done by December the 12th, because one of the things that the U.S. Supreme Court did say in remanding the case to us, they did two things. One, they called our attention to one case called McPherson versus Blacker, which had been decided, and this was the only precedent that they cited. It had been decided in 1894. But that was for the proposition that the legislature had all the power in making determinations as to elections, and that really meaning that we didn't, the state constitution nor our court didn't have any power. That was all up to the legislature. And they also said, you got to pay attention to this safe harbor period, which was going to be meant that we had to have it decided by December the 12th. Well, we had set another oral argument, and we had an oral argument on December the 8th. And actually, we had it on December the 7th. And then that's Barry Richards, here's the GORE team, and we made a decision that night. And on December the 8th, we issued an opinion, and that opinion, we were divided. Because by that time, I had come to the conclusion that we had been through all of this process, and that the margin, it was plain to me that the margin of error in this election was always going to be greater than the margin of victory. That the ballots were so defective as to the counting, and that the statutes didn't have any standards by which any manual recount could be done, and that we had all this conflict in the statutes, that we had arrived at a point where a decision had to be made. Now, another key factor, and I know I've rattled on too long, but another factor here was that by December the 7th, the Florida legislature, that was controlled in both sides by the Republican Party, they were totally disgruntled with the first decision that our court had made, and they had impaneled they had come to Tallahassee, they had gone into special session, and they were in the midst of selecting their own delegation. And so we were about to have a delegation that was pledged to Bush coming out of the legislature. And then the concern was if we had a different delegation coming out of any further recount of this vote, what we were going to have was we were going to have a standoff. And we had to have this decided by December the 12th to stay in the safe harbor provision, or the way it was going to be resolved, it was going to go to Congress, totally uncharted waters. We probably were at least in for 6 more months of litigation, and we didn't have a president. We had a term-limited president, and so we were going to be confronting with a lot of different obstacles. That we should start the count, and that there should be a statewide count. And I thought that was totally impractical, that you could not get that done by December the 12th under any circumstances, and that it was just going to lead to chaos. And so I wrote a dissent, and Then Major Harding and Lee Shaw also joined in. They also dissented. Major wrote a separate dissent. It went back to the circuit court. They started counting, but the U.S. Supreme Court at that point came in. They stopped the count, and then, as you all know, they entered their final order on the 12th of December, and in fact, that's when the matter ended. I'll sum up by saying this. The Bush v. Gore controversy and the 2000 election have come under a lot of criticism, and I certainly understand that. And I understand that courts are subject to criticism, and they should be, because they're the people's courts. They're not lawyers' courts. They're not the judges' courts. They're your courts, our courts. But in the final analysis, one of the things that sets this country apart, and still sets this country apart, and I know our newly minted friend Vladimir Putin doesn't agree, but makes this country exceptional, is that we have a consensus that we're going to be guided even on the transfer of power of the presidency by the rule of law. And there was never really a doubt here that when the final court spoke in this matter, that everyone was going to agree with that this was going to be decided in the court and not in the streets. And the thing that I think all of us can take a great deal of pride in is that what was across the street from the Florida Supreme Court for those 36 days were trucks that had television antennas on them and not machine guns. And that we were able, and so I don't agree with those commentaries that say that this was some scar or some scandal. It wasn't a scandal, it was a mess, but it wasn't a scandal. And it's something, though, that truly sets this country apart. But to tell the truth, I was very glad that by this date, the party was over. Thank you.
Do we have questions?
Yes.
Okay, please wait till I come with the mic.
Okay.
As a result of this election, I believe that the technology of punch cards was discarded
Correct.
to be adopted by something that wasn't really much better. It was also faulty. But in 1979, 1983, I lived in Broward County. And at that time, the supervisor of elections was in the habit of hiring the Broward County League of Women Voters, of which I was one, to groom the punch cards before they were counted. That is, we were there to remove the hanging chads and press the pregnant chads, that is, the dimples. I've always wondered about the legality of that.
Well, I don't know, fortunately, about the legality of that, because that never was a case that came to us. But it seems to me that one of the rules that came out of the 2000 election that we have to understand is that the law as it stands on the day of the election is the law that's going to control. And so if there are no standards by which you would try to remedy the problem with those ballots on the day of the election, then I think you're hamstrung on coming up with some. And as I wrote in my dissent at the end of this case, is that you just have a basket full of practical problems because you don't know who you voted for or who the other person voted for, or you don't know who's the objectivity of the people that are making the decision as to what that means when there's a pregnant chad and all of those different words. So I think it's good that they've been discarded. I agree. We haven't stress tested any of these new systems yet, and there are certain to be some problems with them.
Since 2000, have those election statutes been amended or resolved?
Yes, they have, and that is another good thing that came out of the election now as to whether the new revisions to the statutes have remedied the problem. We don't know yet, but there's a lot of changes that have been made in various counties that I think are going to be positive steps.
I remember that there were some issues with the management of absentee ballots in some counties.
Right.
In particular, not meeting the deadline of arrival and failure to have them notarized and things like that. Was that ever a bench issue? Did that ever?
That was certainly an issue. It was an issue in Hillsborough County. It was an issue in Seminole County. There were several of those issues. Those issues never became a focus of our attention because what we necessarily had to do was to focus on a case that we thought was going to resolve the case in the end. Now, any of those absentee ballot cases could have, because it was so close, they could have been a problem, but none of them really turned out that way, and nor did the butterfly ballot case, because it was really the Chads and that case that were the deciding cases.
I'm glad you mentioned the rule of law. Just the other night, I was in a dinner table conversation with someone who said Gore was very weak in not doing anything more after the decision was made. And I was making the point under the rule of law how patriotic he was. Even looking back other times in history with Nixon being pardoned by Ford and then he loses the election. So I think the fact that we follow the rule of law, and I guess I was right after hearing you say this, because that was my argument on why he was being patriotic, and that's what we do. Mm-hmm. We go with these decisions and we don't take to the streets.
I think that's a very positive factor in these elections, is that we have built a consensus in the country that we are going to have a peaceful transfer of power, and it's harder. It's a hard thing to do.
I notice in your discussions of the a month really, you were involved with this, you didn't really mention law clerks and what role, and obviously you had an enormous amount of material to deal with. I would have thought you would have relied on them quite a bit.
If in my book, which I have written, which is Inside Bush v. Gore, I talk a lot about what the law clerks did and the importance really in this day of at every level of court, but especially at the appellate level, of having law clerks who are talented and who work very, very hard. And throughout this whole period, my law clerks, I had 3, well, they're literally 20 hours a day and working through all of these various issues and cases that we were confronted with, because as the absentee ballot cases and all of those other cases that were coming, at one point it was very apparent that we had cases at every level of court in this country. We had cases in the county court, the circuit court, the appellate courts in Florida, the trial court in the federal level, the appellate courts in the federal level, and the U.S. Supreme Court. So there were just an enormous amount of litigation that was going on in this very concise period of time. As you know, most litigation goes for years, and this was decided in days. So, yes?
is given the role of media now in presidential elections, and given our commitment to the idea of one person, one vote, what is the relevance of the Electoral College anymore?
Well, my only real answer to that is the relevance is it's in the U.S. Constitution, and it's going to stay there because there's not going to, it's practically impossible to get an amendment to the U.S. Constitution. I know Senator Graham and others have questioned it too, and I am very, I'm well aware of the pros and cons of having the electors, but that's part of our fabric, and so we're going to have it, and we're just going to have to deal with the fact that you have this built in since the country was founded, and the small states who would have to really approve taking it out are just not going to do it. So that's...
Are there any additional questions?
Thank you very much.